Good afternoon, ladies and gentlemen. Thank you very much for joining this joint webinar by the Law Society of Hong Kong and Hyogo-Ken Bar Association. By way of introduction, my name is Shohei Tezuka, the Vice Chair of the International Relations Committee of the Hyogo-Ken Bar Association. I'll be in charge of the MC for today's webinar. Thank you very much for your attention. And so let me start in accordance with the program with the welcome remarks by Mr. Susumu Tsukui, the President of the Hyogo-Ken Bar Association, which will be followed by the welcome remarks as well by Mr. Amirari Nasayo, Vice President and Chairman of the International Legal Affairs Committee of the Law Society of Hong Kong. So can I pass on the microphone to Mr. Tsukui for his remarks, please.
Hello everyone. 私は、兵庫県弁護士会の会長の津久井進です。今日の交流会の開催にあたって一言ご挨拶を申し上げます。アミラリナシル副会長をはじめとする香港理事会の皆様とこうして交流会を持つことができたことを本当に嬉しく思います。2019年11月7日に友好協定を締結した後、初めての共催イベントとなります。開催まで準備をしてくださった方々に心より御礼を申し上げます。2020年以降、全世界に影響を及ぼした COVID-19 ウイルスの感染拡大で、どの国も大変な影響を被っています。それは香港も日本も同じです。しかし、この感染拡大を通じて得たものもあります。第一に、世界中がつながっているということをリアルに実感することができました。困難の連鎖を強いられたのがこの2年間だとすれば、これからは相互扶助でつながり合っていきたいと思います。第2に、オンラインで情報交換する手法が一気に拡大したことです。今日こうしてオンラインで交流会をすることができ、香港も兵庫も多くの人数が参加することがこの通りできました。仲良くなる機会を得たことを嬉しく思います。これも一つのイノベーションだと思っています。第3に、直接会って握手を交わし合うことの尊さを、知ったことです。直に会って触れ合えることが当たり前のことではなくて、特別の喜びであるということを思い知りました。直にお酒を酌み交わす日の待ち遠しさを、これほど強く感じることはありません。兵庫県弁護士会は SDGsサスティナブル・ディベロップメント・ゴールズを標榜し、すべての人々に法による平和と公正が行き渡るように、パートナーシップを重視するという方針を立てて取り組んでまいりました。香港理事会との友好関係は、そのパートナーシップの象徴に他なりません。今年を締めくくる12月という時期に交流会を行うことができたことは素晴らしいタイミングだと思っています。ちなみに私は現在52歳、1980年代はちょうど中学校、高校に通っている頃で、ジャッキー・チェンが日本国内でナンバーワンの人気を誇っていました。私もジャッキー・チェンの映画の虜になって、学校でカンフーの真似ばかりをしておりました。香港映画は私の青春時代に欠かせない存在です。また、私たちが執務している役員室には、代々引き継がれている本が入っている本棚があります。そこには、ブルース・リーの映画の DVD が置いてあります。なぜそこに置いてあるのか理由は定かではありませんが、過去の役員の誰かが役員室内でカンフーをやっていた可能性があります。いずれにしても 私たちは香港の文化をとても身近に感じています。今日のテーマは債権回収ですが、カンフーではなく法律を武器にして、権利の実現を図る手立てについて、深い学びが得られることを期待しています。今日はどうかよろしくお願いします。簡単ですが、これをもって私のご挨拶とさせていただきます。
Thank you very much, Mr. Tsukui, for your remarks. And can Mr. Amir Naseo, or the Vice President and Chairman of International Legal Affairs Committee of the Law Society of Hong Kong, can you make the welcome remarks, please?
President Susumu Tsukui, Vice President Satoshi Soga, distinguished speakers, members of the Law Society of Hong Kong and Hyogo-Ken Bar Association. Good afternoon. Welcome to the webinar jointly organized by the Law Society of Hong Kong and the Hyogo-Ken Bar Association. The uninvited visit of COVID-19 has created a new norm preventing travel and stopping all physical meetings and seminars. Fortunately, technology has allowed us to remain connected virtually on the web, unhindered by geographic separation and social distancing laws. It is encouraging to know that over 80 members have registered today for this joint webinar. Facilitating new business opportunities for members is one of the Law Society's important roles. Through the years, we have established extensive connections with lawyers' associations and legal organizations in different overseas jurisdictions, laying a good foundation for collaboration on activities that are beneficial to the respective members and legal profession. Japan has always been a top travel destination for Hong Kong people, and there is strong growing interest for investment in Japan. There is also keen interest for Japanese lawyers to explore business opportunities in Hong Kong. Since 2012, the Law Society has been building closer working relations with lawyers' associations in Japan through our Memorandum of Understanding. Since then, we have had meetings and discussions on ways to ensure the professional competencies and professional standards. We value exchanges and cooperation and are keen to explore opportunities that are in line with our legal needs and changes in the world. Apart from meeting and seminars, we have been working closely with the Japan Federation of Bar Associations on the annual reciprocal internship program since 2014, by providing opportunity for young Japanese lawyers and Hong Kong lawyers to work in local law firms for 2 weeks. Without the assistance from the prefecture bar associations, the program would not have been such a great success. To formalize our commitment for mutual collaboration and support, we signed an MOU with the Hyogo-Ken Bar Association in November 2019. I am confident we will continue to explore innovative ways to foster collaboration and strengthen our members' exchange through meetings, seminars, and in visits in the future, hopefully in the future. I am looking forward to hearing our distinguished speakers who will share their valuable insights and expertise and experience on enforcements and procedures on debt recovery under the law and practice of each jurisdiction. I hope you will find our joint webinar to be informative and a rewarding experience, and I would welcome you and I would welcome your ideas on how to further explore further collaboration between our two associations. Thank you very much.
Mr. Naseo, this is not written in the program, but we try to move on to sharing the corporate video of each association. The first one will be from Hyogo-Bar, so can the secretary of association share the video now, please?
Hyogo-Ken Bar Association is a public interest association that independently manages operations related to attorneys' practice, including bar admission and maintenance of qualifications. All attorneys based in Hyogo Prefecture are registered with this organization. Hyogo Prefecture faces the Sea of Japan in the north and in the south, stretches along the Seto Inland Sea, and ultimately peaks into the Pacific Ocean. The city of Kobe, a port city rich in cosmopolitan flavor, is known for a gorgeous night view from Mount Roko, as well as the world-famous Kobe beef and delicious sweets. Hyogo Prefecture is also home to the World Heritage Himeji Castle, highly popular Takarazuka Review Company, and many more attractive tourist spots. As a region that excels in manufacturing, Hyogo Prefecture provides an ideal environment for cutting-edge research and development in healthcare, energy, robotics, and aeronautics, as well as for traditional industries. It also serves as a hub for a wide range of business sectors from production, logistics, distribution, retail, and so on. Hyogo Prefecture has Kobe District Court and its 9 district court offices, Kobe Family Court and its 9 family court offices, and 14 summary courts. In addition to the Kobe head office, the Hyogo-Ken Bar Association has Hanshin office, Itami office, Akashi office, Himeji office, and Toyooka office. Currently, we have nearly 1,000 members practicing law. We have set up consultation offices at the Kobe head office and local offices for legal advice and referral to an attorney, as well as providing more specialized legal advice and referral to an attorney by specialty area. Hyogo-Ken Bar Association is a public interest association of all attorneys and legal professional corporations based in Hyogo Prefecture. As an autonomous and independent body, we are not supervised by any regulatory agency and can exercise disciplinary rights against attorneys. To promote public recognition of our activities, we utilize a mascot named Himalayan. The Great Hanshin earthquake occurred on January 17, 1995. This large-scale local earthquake of a magnitude of 7.3, occurring underneath the Kobe and Hanshin metropolitan area, took the lives of 6,434 and devastated the livelihood of many, taking away housing and employment. In the afflicted areas, thousands of people sought legal advice, and in order to join the disaster restoration efforts with other citizens, we set up emergency consultation offices at ward offices and city halls, and provided legal advice to 100,000 cases for the afflicted people. 289 attorneys from other prefectural bar associations across Japan also joined as volunteers, and all of us worked as one to help restoration from the disaster. In the light of accelerating globalization of corporate and individual activities, Attorneys Network also needs to keep pace with such globalization. In response to these changes in social environment, we set up an International Relation Committee in April 2016. The International Relation Committee at the Hyogo-Ken Bar Association promotes networking with legal professionals across the world. In January 2019, we visited the Law Society of Hong Kong, and in November of the same year, we concluded a memorandum of agreement with this society, by which both organizations agreed to deepen mutual relationships through visitations, joint seminars, and so on. In 2018, we were visited by the delegates of the Busan District Bar Association and a group of court judges from Thailand. In January 2019, we visited the Law Society of Hong Kong, and in November of the same year, we concluded an agreement with the Law Society of Hong Kong. The International Relation Committee sends committee members to various international conferences. For junior members, we have a financial assistance program to cover costs of attending international conferences. We support our members to excel in international practice through activities such as workshops on foreign law, debrief sessions on studies abroad, seminars on international legal practice, and so on. At the Hyogo-Ken Bar Association, we champion basic human rights and promote realization of social justice through fair application of law.
Thank you very much for your attention. Now, can the Secretary in Law Society of Hong Kong, can you please share your corporate video, please?
The current legal system in Hong Kong was first initiated by the British in the 19th century. Today, the Law Society of Hong Kong has over 10,000 members, including registered foreign lawyers from 30 jurisdictions. In addition, the high proportion of female lawyers reflects the diverse, inclusive, and dynamic character of the Law Society. The Law Society is both the self-regulatory body and professional association for solicitors in Hong Kong. It is entrusted that the duty to monitor the conduct of law firms and lawyers to maintain the highest standards. Meanwhile, the Law Society actively organizes training courses for members, such as continuing professional development and risk management education programs. The Law Society allocates resources to provide relevant and effective support to members, including organizing regular seminars to inform members of the latest development in the law and to facilitate the sharing of experiences on, for example, partnerships with mainland Chinese counterparts. The Law Society has also formed an Innotech committee to promote awareness of various aspects of cyber risk, law tech developments, as well as to lead research on how to advance the development of the legal profession and to build the capacity for young members. The Law Society is independent from the administration, acting as a bridge between the profession and the administration. The Law Society is in constant communication with relevant governmental departments, expressing opinions to improve the practice environment. The Law Society regularly responds from the legal perspective to consultations on different issues. Rooted in Hong Kong, expanding abroad. Thanks to its unique position according to the principle of one country, two systems, Hong Kong plays a pivotal role in bridging the gap between foreign and Chinese enterprises in relation to complex commercial transactions. Capitalizing on the massive potential along the Belt and Road, the Law Society provides support to the legal profession in reaching out. It has established friendly relationships with many legal associations around the world by signing various memoranda of understandings with them. Hong Kong has a well-established legal system and is China's only city practicing common law. It is therefore well-placed as an international center for dispute resolution. Arbitration awards made in Hong Kong are enforceable in many other jurisdictions. Together with a number of other professional bodies, the Law Society has developed an online arbitration, mediation, and deal-making platform to complement the Belt and Road Initiative. The vision of the platform is to integrate advanced technology with Hong Kong's robust legal system to provide reliable and appropriate dispute resolution services to a wide range of enterprises, especially SMEs. Representing over 10,000 members, the Law Society values the importance of social responsibility. Members are encouraged to participate in voluntary works, using their legal knowledge to benefit the community. The Law Society also organizes different kinds of sports, recreational, and social activities to establish connection between members. For more than 110 years, the Law Society has been supported by our members and the community. In the coming years, the Law Society will continue to uphold its vision and mission to safeguard and ensure the fair administration of justice while serving the legal profession.
Thank you very much for the video from both associations. We'd like to move on to the presentation by each society and association. The topics will be debt recovery in each jurisdiction. First of all, I'd like to draw your attention for the Q&A sessions. As you can see from the Zoom, there is set as the Q&A chat box. So we'd like to ask if you have any questions, type your questions in the chat box. But also, if you want to comment on the questions or raise questions verbally, then we'd like to try our best how we can effectively relay, share these ideas, these comments. So first of all, Hyogo-Ken Bar Association would like to deliver the presentation. The first part will be from Mr. Yasutomo Wakiyama, the member of International Relations Committee of Hyogo-Ken Bar Association. So can Mr. Wakiyama start your presentation with sharing the screen if you're ready, please.
Nice to meet you. My name is Yasutomo Wakiyama. I am a member of Hyogo Bar Association and International Exchange Committee. Today, let me give you a presentation in Japanese from now on. Thank you. Let me share the file.はい、私の方からは、債務の不払いなどの、問題が起きる前の、平時の段階で、将来の債権開始の実効性を確保するために、どのように債権管理をするのか、どのような実効性確保手段があるのかについて説明したいと思います。はい。まず、債権の管理についてですけども、まず消滅事項というものについて説明します。債権が、事項により消滅するまでの期間について説明します。2017年の改正前の民法では、消滅事項期間が債権の種類によって多岐に分かれていましたが、現在の民法では次のようにシンプルになっています。つまり、一般の債権は債権者が権利を行使できることを知ったときから5年間行使しないとき、または権利を行使することができるときから10年間行使しないときのいずれか早い方の経過で消滅します。通常の売掛債権の場合は、支払い期日になれば売掛債権を回収できることを債権者は知っているので、現在の実務では一律5年間で債権管理すべきとされています。次に、不法行為による損害賠償請求権は次のように定められています。つまり、被害者またはその法定代理人が損害及び加害者を知ったときから3年間行使しないとき、または不法行為の時から20年間行使しない時のいずれか早い方の計画で消滅します。もっとも不法行為による損害賠償請求権の中でも人の生命、身体を害する不法行為による損害賠償請求権については債権の保護の必要性が高いため、前述の3年間ではなく5年間とされています。次に、時効の援用について説明したいと思います。時効の効果は、時効の利益を受ける当事者が時効を援用したときに初めて発生します。つまり、消滅時効期間を過ぎても、債権者が消滅時効を援用しない限り、債権を回収できます。 また、消滅時効期間が過ぎた後に債務者が債権の一部を支払ったり、支払いの猶予を求めたりしたときは、それ以降は時効を援用できなくなります。次に、時効の完成を阻止する制度について説明します。時効の完成を阻止する制度としては、時効の完成猶予と時効の更新があります。時効の完成猶予とは、一定の完成猶予事由が生じた場合に、所定の期間、時効の完成が猶予される、時効の完成が先延ばしにされるという制度です。一方、時効の更新とは、一定の更新事由が生じた場合に、時効の進行が一度リセットされ、またゼロから時効期間が進行するという制度です。具体的に見ていきますと、例えば、口頭や書面で裁判外において支払いを請求した場合、6ヶ月を経過するまでは時効の完成が猶予されます。次に、訴えを提起した場合、例えば、まず、訴えを提起時に時効の完成が猶予され、確定判決などで権利が確定したときに、時効が更新され、時効期間が新たにスタートします。次に、期限の利益の喪失というものについて説明します。期限の利益とは、債務者が期限まで弁済を猶予される利益です。しかし、期限まで待っていると、債務者が弁済をすることが期待できない場合にまで、債権者が期限まで回収できないというのは不合理です。そこで、日本の民法では、1つ目、債務者の破産手続き開始決定、2つ目、債務者による担保物件の価値減少行為、3つ目、債務者による担保提供義務違反のいずれかがあった場合には、債権者が債務者に意思表示をすれば、債務者の期限の利益が消滅するとされています。また、これだけでは十分ではないので、通常の契約書において、債務者が期限の利益を喪失する場合についての定め、いわゆる期限の利益喪失条項を定めます。例えば、支払い停止、手形の不当たり、第三者からの差し押さえ、破産申し立てなどの重大な事由については、債権者から通知催告がなくても当然に期限の利益を失うと規定します。これを当然喪失条項と呼びます。また、そこまで重要ではないが、契約違反や支払い懈怠など一定の信用不安があった場合に、債権者からの請求によって期限の利益を失うと規定します。これを請求喪失条項と呼びます。次に続きまして、日本の担保の制度について説明したいと思います。将来の債権開始の実効性を確保するための担保の制度についてお話しします。まず、物的担保についてお話しします。物的担保の種類ですけども、まず、物的担保について、日本ではここに記載されているような、不動産、動産、債権、有価証券などの物件を担保の対象とすることができます。実務における留意点について説明します。まず、実務でよく使われる抵当権について説明します。抵当権とは、相手から支払いを受けられない場合、債権の担保のために提供された不動産を競売したり、その不動産の賃料を差し押さえることにより、他の債権者に先立って債権の弁済を受ける権利です。不動産に担保を設定するときの最もスタンダードな方法が抵当権の設定です。抵当権を設定する前に、不動産登記簿謄本、不動産の登記ですね、と、構図、現地の調査、査定などによって、十分な調査を行って、債権をカバーする十分な担保価値があるかどうかをチェックすることが重要です。 そして債務者との間で抵当権設定契約を締結し、第三者に対抗するために抵当権設定登記を具備します。他の債権者も抵当権の設定を受けている場合、先に登記を具備したものが優先されます。続きまして、動産譲渡担保について説明します。動産譲渡担保とは、相手のめぼしい財産が大型工作機械などしかない場合、債権の担保のために形式上は担保権者に機械を譲渡して所有権を移転させますが、債務者にその動産の使用収益を認めるという担保です。債務者の事業にとって、重要な機械などを債務者が使用している場合で、これを売れば相当の売買代金を得ることが見込めるときは、その機械などを動産譲渡担保に取るのが適切です。第三者に対抗するために引き渡しが必要ですが、債務者が対象物件を使用しているため、意思表示だけで引き渡したことになる方法である占有改定という方法によって引き渡すことを契約書に明記すべきです。もっとも、債務者が法人の場合は動産譲渡登記を利用できます。対婚要件を具備しても事情を知らない無過失の第三者が、取得する恐れがありますので、対象物件が自社の所有物件である旨のプレートやステッカーを貼って、自社に所有権があること、一切の処分が許されないことを公示することが重要です。続きまして、集合動産譲渡担保について説明します。集合動産譲渡担保とは、動産譲渡担保のうち、債務者の特定の店舗や倉庫内にある在庫商品を一括して譲渡担保の目的とする担保です。債務者が商品の出し入れを繰り返しながらも、特定の店舗や倉庫にいつもある程度の在庫商品を保管している場合には、在庫商品を一括して集合動産譲渡担保に取り、いざというときに在庫商品を引き上げて換価処分できるようにしておくことが適切です。債務者が法人の場合は、動産譲渡登記を利用できることは先ほどと同様です。集合動産譲渡担保設定契約では、通常の営業の取引の範囲内で在庫商品を販売することを認めるのが通常です。しかし、担保価値を維持するために販売した商品分の商品を保管することを債務者に義務付ける必要があります。また、担保状況をチェックするため、債務者に対して在庫商品の保管状況を定期的に報告させるべきです。集合動産譲渡担保では、担保の対象となる在庫商品が日々入れ替わるので、個々の商品を契約書で特定することはできません。日本の判例では、対象を種類、所在場所、量的範囲の3つの基準で特定することにしています。量的範囲については争いになりやすいので、一切の商品などと記載するのが無難です。さらに在庫商品が譲渡担保の対象物件であることは第三者には分かりませんので、その旨のプレートなどを保管場所の倉庫の入り口などに貼り、自社に所有権があることを分かるようにしておきます。続きまして、集合債権譲渡担保について説明します。集合債権譲渡担保とは、継続的な取引の当事者間で、現在の債権および将来発生する債権を一括して譲渡担保の目的物とする担保です。債務者に不動産や在庫商品のような資産はないけども、回収できることが確実な売掛金がある場合に集合債権譲渡担保を利用するのが適切です。まず集合債権譲渡担保設定契約では、債務者が将来取得するであろう売掛金などの債権についても担保設定しますので、債権を完全に特定することはできません。しかし、ある程度特定してこなければ、誰に対するどの債権の譲渡を受けたのかが不明です。そこで第三債務者、つまり担保対象の債権の債務者の称号 名称、住所、債権の種類および債権の発生期間を明記します。債権の発生期間は実務では5年程度とすることが多いです。対抗要件としては、債務者が法人の場合、債権譲渡登記を利用することができます。最後に、日本では、人的担保とも呼ばれる保証について説明します。保証とは、主債務者がその債務を履行しない場合に、保証人が主債務者に代わって債務を履行する責任を負うことです。保証契約は債権者と保証人との間の契約であって、主債務者は当事者ではありません。保証の種類について説明します。普通保証は民法が基本形態としている保証です。次に、連帯保証は、主債務者が履行期になれば、債権者は直ちに保証人に対して保証債務履行を請求でき、保証人はこれに応じなければならないというものであって、金融機関が保証する場合はほぼすべてこのタイプの保証です。また、一定の継続的取引関係から現在および将来において生じる不特定の債務を保証するものは目保証と呼びます。さらに、公益法人である信用保証協会という機関が、各都道府県に1つずつ設定されており、中小企業などが金融機関から貸付などを受ける場合に、その貸付金などの債務を保証し、信用力の乏しい中小企業などにも融資を受ける道が開かれています。続きまして、実務における留意点について説明します。まず、保証人保護の観点から、保証人の意思の確認は非常に重要です。そもそも保証契約は、書面でしなければそもそも無効です。また、主債務者が事業のための借り入れである場合で、個人が保証する場合は、公正証書を作成しなければ無効です。同様に、保証人保護の観点から、保証人に対する情報提供義務も定められています。つまり、保証契約締結時に、債務者は保証人に対し、債務者の財産、収支の状況などの情報提供をしなければなりません。また、保証契約継続中や主債務者が期限の利益を喪失したときにも、情報提供義務が定められています。最後に、2013年12月に、日本商工会議所と全国銀行協会が共同で、策定したソフトローである経営者保証ガイドラインについて説明します。こちらのガイドラインができるまでは、法人が破産した場合、保証人である代表者も共に破産するというのが日本では一般的でした。しかし、このガイドラインを用いて破産手続きによらずに99万円、これが破産の時に残せる財産ですけども、に加えて、必要な生活費を残すことが可能となり、事業に失敗した代表者に再チャレンジのチャンスを与えています。金融機関もこちらのガイドラインに基づく債務整理に誠実に対応する必要があり、基本的に前向きに対応してくれます。私自身も法人の破産事件を多く取り扱っていますが、法人が破産してもその保証人である代表者はこのガイドラインによって処理することが多く、私もすでに10件以上経験があります。はい、ひとまず私からのプレゼンテーションはこちらで終わりたいと思います。ありがとうございました。
So thank you very much, Mr. Wakiyama, for your wonderful presentation. And the second part of the presentation from the Hyogo Bar Association will be delivered by Mr. Naohisa Hirata. He will talk about the collection of claims in Japan, with a focus on the legal procedures for the collection. So perhaps Mr. Hirata, if you are ready, can you share the screen and start your presentation, please?
Nice to meet you. I'm Naoshita Hirata, a member of Hyogo-Ken Bar Association. I would like to introduce you about the Japanese legal procedures for correcting aggression of claim. 私からは通常の債権回収ができなくなった場合、つまり強制執行や担保の実行が必要になった場合の債権回収についてお話しします。入ってますかね。はい。私からお話しする内容はこのアジェンダに記載の通りです。ちょっと時間もありませんので、アジェンダについては割愛いたします。はい、まず強制執行手続きについてお話をいたします。強制執行のための要件について簡単にお話をします。強制執行をするためには、まず債務名義を取得する必要があります。ここでどのような文書が債務名義になるのかということについて、次のスライドでご紹介をします。1は確定判決です。これが最も一般的に利用されている債務名義になります。他によく利用されているのは4の執行証書です。これ執行証書について次のスライドで詳しくお話をします。執行証書というのは交渉人が作成した契約書の文書で金銭債務について債務者が直ちに執行に服する旨の文言が記載されたものを言います。契約を締結する際に、この執行証書を作成しておけば、債務者がお金を払わない場合でも、裁判を行わずに、直ちに強制執行に取り掛かることが可能になっています。この執行証書はいろんな場面で利用されています。特に離婚の合意書において、養育費の支払いについて定める場合や、高額の不動産の賃貸借契約などで利用されることが多いです。他に執行証書、他の債務名義ですけれども、7番の確定判決と同一の効力を有する文書、これには例えば裁判上の和解調書や調停調書があります。これも非常によく利用されています。他の要件を見ておきましょう。次に、債務名義の債務者への送達が完了している必要があります。例えば、確定判決を債務名義とする場合、その判決を行った裁判所に送達証明書を発行してもらうことができます。それから3つ目に、執行証書というものを取得する必要があります。執行証書とは、債務名義が執行力を有することを証明する文書です。例えば、確定判決をなど、裁判所が発行した文書であれば、裁判所書記官が執行文を発行します。交渉人が作成した執行証書の場合は、交渉人が執行文を発行します。債務名義に記載された請求権に何らかの条件が付されている場合、例えば特定の日にならなければ請求できないとか、担保を提供しなければならないとか、こうした場合、債権者は執行分の付与を受けるにあたって条件が成就したことを示さなければなりません。次に、金銭債権の強制執行手続きについて具体的に見ていきます。日本の民事執行法には、金銭債権の強制執行手続きとして、ここに挙げた4種類が規定されています。 このうち1と2について詳しく見ていきたいと思います。ここにお示ししたのは、不動産強制執行の手続きの流れになります。まず、債権者が裁判所に強制執行の申し立てをします。この時、裁判所は先ほど見た要件を満たしているかどうかという審査を行います。そして、債権者は予納金を裁判所に支払わなければなりません。これは不動産の鑑定など執行の手続きの費用に充てられます。一般的な不動産であれば、1件あたり50万円程度の支払いが必要になります。なお、この費用は後の配当手続きにおいて優先的に支払いを受けることができます。次に、裁判所は申し立ての要件を満たしていると判断した場合、競売の開始を決定します。この時、裁判所から法務局に連絡がされ、法務局において差し押さえの登記がなされます。3番目、競売開始が決定されると、裁判所の執行官によって不動産の調査が行われます。誰がこの不動産を使用しているのかや、賃借人、担保権など、そういった権利が設定されていないかといったことが調べられます。また、不動産鑑定士によって不動産の価値が鑑定されます。この調査の結果は3点セットと呼ばれる3つの文書にまとめられて、裁判所に報告をされます。次のスライドを見ます。これは裁判所が公開しているウェブサイトになります。現在どのような競売が行われているか、裁判所のウェブサイトで見ることができます。このサイトでは、先ほどお話しした3点セットを PDF でダウンロードすることができます。入札に参加する人は、これを見て購入を検討します。手続きに戻りまして、裁判所は3点セットを確認すると、売却基準価格を決定します。これが入札を行う人の目安となります。そして入札を行って、裁判所は落札者にその不動産を売却してよいかどうかという審査を行います。例えば、反社会的勢力に加担している人間は、購入者となることができないと定められています。落札者に特に問題がなければ、代金の支払いがなされ、物件や登記の引き渡しがなされます。そして、最終的に配当がなされるというのが、大まかな手続きの流れになります。10ページに移ります。不動産競売と並んでよく利用される強制執行の手続きは、債権の差し押さえです。差し押さえられるのは銀行の預金や生命保険の解約返礼金、売掛金や給与などです。債権差し押さえの手続きですが、まず債権者が裁判所に申し立てを行います。この時、誰に対する債権なのか、どのような原因による債権なのかを具体的に特定する必要があります。例えば、銀行の預金を差し押さえる場合、銀行名を特定するだけでは足りず、支店名まで特定をする必要があります。ただし、口座の種類や口座番号まで特定することは不要です。債権の発生原因が実際のものと異なっていれば差し押さえはできませんので、慎重に検討をする必要があります。裁判所は申し立てに問題がなければ差し押さえ命令を出します。差し押さえ命令が第三債務者に送達されると、第三債務者は債務の弁済を禁止されます。例えば、銀行であれば、裁判所から差し押さえ命令の送達を受けると、直ちに預金を特別な口座に移し替えて、債務者に引き出されないようにします。また、差し押さえ命令は債務者にも送達されます。 そして、債務者に差し押さえ命令が送達されてから7日を経過すれば、債権者は第三債務者に対して直接自分に債務を弁済するよう要求することができます。もし第三債務者が債権者に支払いをしようとしなければ、債権者は訴訟によってこの支払いを求めます。11ページに移ります。日本の法律では、差し押さえを禁止される債権がいくつか定められています。これは債務者の生活を保護するための規定です。例えば、ここに挙げたような債権が差し押さえを禁止されています。ただし、ここに挙げた債権も、一旦銀行預金に振り込まれてしまうと、差し押さえすることが可能とされています。この制度については反対の声も多く議論がされているところです。金銭債権の強制執行手続き以外にどのような手続きがあるか、項目だけご紹介をしておきます。ここに挙げたような手続きが民事執行法に規定をされています。この中でよく利用されるのは、1の不動産の引き渡しです。建物の借り主が物件を返そうとしないとき、この手続きをよく利用します。また、6番の意思表示の犠牲というのは、裁判によって登記を移転する際によく利用されています。次に、担保権の実行についてお話をします。担保権の実行について、日本の民事執行法にはあまり規定はありません。ここに書いた3つの手続きしか規定はされていないということになります。ただし、これは担保があまり使用されていないということを意味するものではありません。例えば、銀行預金に質権を設定している場合、銀行があらかじめ質権の設定に同意していれば、担保実行に際しても任意に支払いを行ってくれるので、法律上の手続きは必要ないということになります。この3つの中で、頻繁に利用されているのは、1番の不動産担保の実行です。この手続きは、先ほどの不動産競売手続きとほぼ同じになっています。しかし、大きく異なるのは、申し立てにあたって債務名義の代わりに、担保権が登記された登記簿謄本を提出すればいいということです。非常に簡単に申し立てが可能ですので、申し立てを弁護士に依頼しないという銀行も多くあります。これは私たち弁護士にとっては少し問題かもしれません。さて、債務名義を取得したとしても、差し押さえる財産が発見できなければ、債権を回収することはできません。そこで、日本における財産開示の手続きについてご紹介をいたします。財産開示手続きの流れを簡単にご紹介します。まず、申し立てを行う債権者は、債務名義を取得している必要があります。そして、それだけでは足りず、ここに記載した A か B のいずれかの条件を満たしている必要があります。A は債権執行の申し立てをしたが、全額を回収できなかったというもの。B は強制執行しても全額の回収できないということを訴命するというものになります。そして、これらの要件を満たすと、裁判所が認めた場合、裁判所は開示期日を定めて、債務者を裁判所に呼び出します。開示期日においては、債権者や裁判所から債務者に対して、どのような財産を持っているのかという質問がなされます。債務者は宣誓をした上で、この質問に正直に答えなければなりません。この財産手続きは、2003年の法改正によって導入されました。しかし、実は最近までほとんど利用されていませんでした。それは、期日への出頭を拒否したり、虚偽の説明をしたりしても、軽い罰則しか受けることがなかったためです。しかし、2020年から罰則が強化され、違反した債務者には刑罰が課されるようになりました。 これによって、財産開示手続きの申し立て件数というのは非常に大きく増大しています。また、第三者からの財産情報の開示を受ける制度というのも2020年にスタートしました。これには3種類の制度があります。まず1つ目ですが、銀行に対して債務者の預金の有無や残高を問い合わせることができます。ただし、この制度については、実は私たち弁護士は、これと同じ問い合わせを弁護士法による手続きによって行うことができます。以前は回答を拒否する金融機関もいくつかありましたが、現在はほとんどの金融機関が私たちの問い合わせに回答してくれるようになっています。2つ目は、債務者が権利を有する不動産について、法務局から情報提供を受けるというものです。しかし、実際の債権回収の事案では、債務者が不動産を持っているということはあまりないと思いますので、あまり有効な手段とは言えないかもしれません。3つ目は、債務者がどこから給与が支払われているか、自治体や年金機構から情報を取得するというものです。この手続きはかなり強力なものです。例えば、今までは離婚の際に約束した養育費の支払いを怠っている債務者がいたとしても、どこで仕事をしているか、後をつけて調査でもしなければ、給料を差し押さえることはできませんでした。そのため、養育費を支払わないという事案がたくさんありました。しかし、この手続きを利用することによって、債務者は逃げられないということになっていきます。ただ、この手続きは強力な手続きであるために、申し立ての要件が厳しく設定されています。子どもの養育費や婚姻費用の分担など、家族間の扶養に関する債権、あるいは生命や身体の損害に関する賠償請求についてしか、この手続きを利用することはできないというふうにされています。まだこれらの制度は運用が開始されたばかりですので、この後、どの程度利用されるのか注目がされています。最後に民事保全手続きについて少しご紹介をいたします。裁判で勝訴判決を得たとしても、その前に財産を隠されてしまっては、債権回収は困難になってしまいます。そのようなことがなされないようにするために、訴訟を提起する前に財産を仮に差し押さえるという手続きが定められています。ここでは代表的な手続きとして、不動産に対する仮押さえの手続き、仮差し押さえの手続きを見ていきます。申し立てにあたっての要件は、ここに挙げた2つになります。1つは、債権の存在について訴命をするということです。もう1つは、仮差し押さえの必要について訴命をすることです。この訴命のために裁判所に契約書などの書面を提出したり、面談を行ったりということをします。次にですが、裁判所はこれらの要件を満たすと判断した場合、債権者に担保を提供するよう求めます。通常は法務局において供託を行うことによって、担保の提供を行います。おおむね7日以内に担保を提供するように求められます。ですので、申し立ての際にはあらかじめお金を用意しておかなければいけません。担保の提供を確認すると、裁判所は仮差し押さえ命令を出します。不動産の仮差し押さえでは、この命令によって仮差し押さえの登記がなされます。実務上、仮差し押さえにおいて重要なのは、担保金を用意できるかどうかというところです。担保の金額は、債権が存在することの確実性と、仮差し押さえによる債務者の不利益によって決まります。債権が不確実なものであるほど、また仮差し押さえによる不利益が大きい財産ほど、担保の金額は高くなります。この表は、裁判所が示しているおおよその基準ということになります。はい。 以上で私の発表を終わります。ありがとうございました。
Thank you very much, Mr. Hirte. Can you stop the sharing screen? Oh, thank you very much. Thank you very much for all the Hyogo-Ken's presentations. And we'd like to move on to the presentations by the Law Society of Hong Kong, and which will be followed by the Q&A session for both of the presentations. And for the speakers of the presentations of Hong Kong side, let me introduce two speakers, Mr. Ronald Sam, who is a council member of the Law Society of Hong Kong, and also Ms. Hyogo-Ken, who is a member of Standing Committee on the External Affairs of the Law Society of Hong Kong. So can you perhaps start your presentation, please, if you're ready?
Yes, we're ready. I think before we start our presentation, we're going to say a few words because Ronald and I, we are both litigators. So we have decided that we'll concentrate and focus our session on the litigation side rather than going through the types of assets because that will be not as exciting. So I think before we actually start, I'll give you some very basic background of the Hong Kong litigation system so that you will have a better understanding of how our court actually functions first. Can we go to the slides? So the next one, if I press. Okay, here we go, finally.
We're back in business.
Exactly. So it's the basic court structure. We have got the small claims tribunal. There's a district court, high court, and a court of final appeal. So there are these four kinds of courts that deal with debt recovery cases only. So if I move to next slide. Okay, small claims tribunal. So they only basically listens to minor monetary claims involving amounts not exceeding 75,000 Hong Kong dollars. So it's quite small the amount. The hearings are actually quite informal in the tribunal, and no lawyers are allowed to represent either side. So it's more like a kind of a venue for litigants in person to try to handle their dispute directly between themselves. And some people may think that because if you don't need lawyers, maybe it will be a clever way to divide their claims into small amounts of claims that under $75,000 just to fit into the small claims tribunal. But unfortunately, this is not allowed. So you can, unless you want to forego the rest of the amount just to claim for the 75,000 Hong Kong dollars. Otherwise, you will have to use another court. So before commencing a formal trial at the tribunal, the adjudicator and the tribunal officer will attempt to mediate the dispute between the parties. So it's kind of an informal setting. So that's how it works. For the next one, if we can move to the next slide. Okay, district court. District court handles cases where the amount is over $75,000, but less than 300,000 Hong Kong dollars. Okay, so it's called district court. The high court. Okay. High court comprises of the Court of Appeal and the Court of First Instance. Okay, so it's two different things. So the first one is Court of Appeal. That's the final court to go for if it goes from to hear appeals on civil matters from the Court of First Instance and the District Court. The Court of First Instance is unlimited in civil matters, but it also hears appeals from the small claims tribunal. And lawyers are allowed to represent clients in the Court of First Instance, and in fact a lot of cases are heard in the Court of First Instance. The majority of cases, I think. Can we move on to the next slide? Okay, Court of Final Appeal, that's the highest court in Hong Kong. And basically it handles all the cases that goes to appeal from all the lower courts. They have actually got a tribunal. So basically, it's constituted a chief justice, 3 permanent judges, and 1 permanent Hong Kong judge, or 1 judge from another common law jurisdiction. So it's basically the full and final say in Hong Kong, this court. Okay, I just want to talk very briefly about Hong Kong law so that it gives you a brief background of how we work. We basically follow the English common law system. And the interesting part about the common law system is that we heavily rely on case precedents, which means that all the judicial decisions before the court will take into account. So not only the written law, but also case law from all other jurisdictions from the common law world will be taken into account. So this is quite different from civil code countries. In terms of cost issue, I think you will need to be aware of as well, because unlike UK or US and some other countries, Hong Kong, no conditional fee agreements or contingency fee agreements allowed in litigation. Legal aid is available, but people who wish to apply for legal aid will need to meet the means and the merit tests. And generally speaking, in terms of who gets the money back at the end of the day, the winner basically nearly wins all. So this means that the winner, whoever wins the case, can normally recover about 70% of legal costs plus the damages awarded by the court. The losing party will need to pay for his own legal costs plus a majority of the other side's costs and the damages awarded by the court. So it's a gamble for both sides. In terms of time limitation, for most debts, the time limit is 6 years from the date of the breach. And the time limit is actually longer for mortgage debts. And judgment debt, can be brought about 12 years after the date on which the judgment became enforceable. So it's a lot longer for judgment debt. If you go to the next one. Yeah, I'll also talk very briefly about the burden of proof and standard of proof, which I think you will need to know as well. The burden of proof in Hong Kong rests on the party who asserts the fact. So basically, whoever allegates the allegations will need to prove that. So the majority of cases, the plaintiff will have the burden of proof to prove what he wants to allegate against the defendant. And the standard of proof in civil case is basically a balance of probabilities, i.e. more probable than not. So it's not like criminal cases where it's beyond reasonable doubt. Now, I'll give you a very, very fast overview of the civil claim procedure. So we basically divide it into stages. The pleading stage is where we issue writs, where the defendant acknowledgement service, file defense, and plaintiff can file the reply. Then we'll have the discovery stage where both parties will basically disclose what kind of documents they have in possession so that the other side can see what they have got. And then there will be the court directions on case management. So the court will basically take over in terms of how to progress the case. And then if the parties are unable to mediate to try to settle the case, then we'll go to trial. So in any time during the proceedings, the parties can try to settle the case. So mediation is encouraged in Hong Kong, and in fact, parties will have a cost impact if they don't want to follow mediation. So this is also something you will need to bear in mind. So I think we will go to a more interactive part of this presentation. I'll pass to Ronald.
Thank you very much. My name is Ronald Sum. Can I have the slides uploaded? Yeah. Law is a rather boring subject. So what we have decided to do is to make it more fun. How do I make it more fun? is that I will be acting for a client called a Creditors Company. Creditors Company actually is incorporated in the BVI. It's not in Hong Kong, incorporated in the BVI. My learned colleagues here, Olivia, she happens to be representing in a company called Debtors Co. Okay, obviously from the name, Debtors Co. owe my client some money. So my clients come to my office and very unhappily said that Debtors Co. owes them money. My client then tells me Debtors Co. is represented by Ms. Olivia Kong here. So my first question to them is that you have heard what Olivia have said. Because of the court system, because of the adverse cost structure, the first thing as a lawyer in Hong Kong, I'll ask, where is the source of the debt? Is it by way of a contract? Is it written? Is it oral? So we call this the evidence gathering stage. I presume that our learned colleagues in the Hyogo-Ken Bar associations will also start with that questions. Obviously, the next questions is that have there been any communications between the parties? The Hong Kong courts adopt an adversarial system, which means that I'm acting as the creditors, Ms. Kong is acting as the debtors. We all present our case in front of a judge. But many of the courts in Hong Kong, in fact, all the courts in Hong Kong, don't like to see a party just jump into an action. So we usually have what we call a letter before action, which means that to set the scene by saying that I act for Creditors Co., sending it to Ms. Kong, setting out why we are claiming the debts in a rather polite format, so that Olivia will know what the claim is more or less about. Obviously, as the creditor's lawyer, we're going to put in the full claim amount, okay, whatever we are claiming, plus legal costs, and also at times plus interest as well, depending on when the debt occurs. Now, these are all the peripheral issues. And the bottom line is that any clients in the world will go to a lawyer and say, well, I don't want a paper judgment. I want some money back from Debtors Co. So you're venturing into the investigation stage. Now, obviously, it's to say the obvious, you have the location of the assets, the location of the directors of the debtors, because later on you will see that there is an enforcement procedures called oral examination where the creditors can ask the debtors or the directors of the debtors, if they are a company, to answer a couple of questions. And of course, the location of the guarantors. In many of the big significant contracts, there will inevitably be guarantors. Okay. Oops. Hold on. Okay, now, of course, having looked at the different types or the location of the assets of the guarantors, we're looking at what are the assets? Guarantees, are they personal or are they company? Mortgages, pledge, assignments. I believe that Wakiyama-san and Hirata-san has briefly set out the definitions of some of the mortgages, assignments, etc., in your civil code. In Hong Kong, although we do not operate on a civil code basis, but the definitions are more or less similar. That's all I can say. So we are not going to spend time dwelling into that. Obviously, there are the fixed assets, there are the removables. One thing that has cropped up recently in some of the multi-billion dollars bond issues default is what they call the keep well deed. It is unsettled law at the moment. Some jurisdictions accept keep well deeds as similar to a guarantee. Some jurisdictions, they don't. Hong Kong is a question mark on this, and there is currently a case tested in courts regarding the validity of the keep well deeds. So we will just have to wait and see. Now, obviously, you have the mortgage, you have the keep well deeds or the guarantees. How much are they guaranteeing? It may not be the full amount, it may just be a percentage. So all these comes into play. And of course, I would need to ask my clients, well, are you a secured creditors or unsecured creditors? Because if you are an unsecured creditors, you are ranked pretty low in the list of creditors. So you need to, as a lawyer, we will need to advise the clients that the prospects of winning the case and the prospects of recovery. Now, going to time bar, now you will see immediately that Olivia says 6 years, I said 2 years here. Now the contractual time bar is under the limitation ordinance. We put it called Chapter 347, Section 4. What Olivia says is correct, and what I said is correct, is that in different circumstances, there will be different time bars. Personally, I would like to take the shortest time bar, because once you miss the time bar, that's the end of the claim. Okay, you cannot say that, oops, I missed the time bar, the client comes in too late. Okay, the Hong Kong courts will simply not accept that. So personally, I will always treat 2 years, even though legally it may be 6 years. It is on the caution side, I will treat it as 2 years, because some circumstances, as I said, it's only 2 years. Some circumstances, there may even be 1 year. The Hong Kong law allows a contractual time limit of 1 year. You can opt out of the limitation ordinance and specifically put down the 1 year time limit. Now, having looked at all the assets, whether my clients have a claim, then it's the law and jurisdiction clause. Now, in that respect, does it have to be court proceedings? Is it in Hong Kong? Is it in Japan? Do I have to instruct a Japanese lawyer? Is it alternative dispute resolutions? Is it arbitration? If it is do you have to go through mediation first and then arbitration? So all these are important questions, because this affects one thing, the cost, and how much my clients will get the money back. What is the portion of money that my clients will get back? And of course, different jurisdictions do have different time bars. So this becomes very important. Now, having considered all that, I usually talk to my clients about strategies. Okay, whether it's court litigation, the run-of-the-mill court litigation, arbitration, or is it a statutory demand under the company's ordinance, winding up a miscellaneous provisions ordinance, chapter 32, section 178(1). I'll be talking about that further later on. Or are we simply causing trouble? Okay, a cause trouble strategy where we do not want to wind up the debtors. Okay, we just want to cause enough trouble to put enough pressures on the debtors to pay up. Sometimes the debtors are so huge and massive, and they have different offices around the world. And in one jurisdiction, they may go bankrupt, and they may not accept my clients, which is in BVI, as the creditor. So we are just here to cause trouble so as to recover some money. So these are the common strategies. And of course, the status of debtors, which I have talked about. Now, having considered all that, I'll talk to my clients. Okay, let's go and commence litigation against debtors code. Now, my clients are going to ask me, well, Mr. Sum, you sound very confident. Should I be concerned about certain things? One of the things that I am very concerned, if my creditors is an overseas company, will be something called security for cost. So I am sure that Olivia will enlighten us on the strategy a debtor will use in slowing down my client's recovery, the creditor's recovery. So over to you, Olivia.
Okay, so one of the tactic I think for debtors is to try to delay the process. The plaintiff job is to try to push the case forward as fast as possible. So the defendant is to delay this. And one of the best tactics to use for defendants is to go for security for costs. Basically, especially if the plaintiff is not located in Hong Kong, so a foreign company. The point of this security for costing is for the defendant to ensure that in the event that if he won, at least he gets to get the cost back. Otherwise, it will be going for nothing because he's basically being dragged into the litigation involuntarily. So that's one of the tactics to use, because once if the court, if assuming that the test is passed for going for the security of costs, which you can see on the slides, what kind of criterion you will need to meet, then say my client managed to convince the court that Ronald's client will need to pay security costs into court, then at least I know that if I continue with this game, if I won, I'll get some money back.
Yes. Now, and then suddenly I will receive a letter from Olivia saying that a rather nasty one, I would say, saying that if I do come in, usually the reply letter to the letter before action is that creditors go, you do have no claim, but if you do insist to commence proceedings, we will definitely go to the court and make an application for security for cost. Now, immediately, creditors co is going to ask, well, how much I have to pay? The nightmare on this is that Olivia can ask multiple security for costs. That means that at any stage of the proceedings, right up to the final hearing, she can ask, or her clients can ask security for costs. Sometimes it may be in millions of dollars. You've got to understand that in the litigation process, in the debt recovery process, before you can get any money, you are venturing into the process, getting the money, you are already paying $1 million or even $2 million into court. And the creditors code will feel that, well, I have not even received any money, but I have to pay some cost into the court. That is a slow down process, obviously. The reverse does not apply for the creditors. I cannot ask, my clients cannot ask Olivia's client for security for cost because debtors code happens to be incorporated in Hong Kong. Now, but what our creditors code can do is to obtain an injunction, a relatively difficult process in court. One of the major things that you get from an injunction is to prohibit debtors code from selling or disposing of the assets. Now, it is a very, very good strategy because similar to debtors code, similar to Olivia's client, and they are worried that if creditors code lose and we have to pay cost, debtors code are concerned that we may not have the money to pay. Similarly, for creditors code, if they win, they are concerned that debtors code may not have money to pay. So right at the beginning, depending on the situation, creditors code will make an application for an injunction prohibiting debtors code in disposing some of the assets. Now, this is a cumbersome process and it's a difficult process. It is difficult, as you can see, because you are prohibiting someone or some entity from disposing the assets before even a judgment. Okay, in Hong Kong, you are innocent until proven guilty. Okay, that's the concept. But you are not proven guilty yet, and you have injunct or prohibit someone from disposing the assets. So you can actually see the high burden of proof from the courts in Hong Kong. And of course, after we have done all the interim measures, as we call it, then obviously there are different ways of proceeding with the debt recovery. Of course, there's the companies winding up. We can go to wind up the companies, or we can proceed with full-blown litigation. Now, there are various grounds of winding up a company. The company is unable to pay its debts. The court considers it is just and equitable that the company should be wound up. Now, majority of the cases is that this company is unable to pay its debts. So it is very clear-cut. I think I can use the word clear-cut. If it is that clear-cut, then it is a shortened process. You can see from the slides that there is something called statutory demand. It is in a prescribed form, setting out why debtors owe creditors some money. It's in a prescribed form. The reasons why, for example, you have creditors have pressed on with the debts already, still no payments. It is a debt due and payable. This is very important. It's a debt due and payable. So there's no argument on it. So it's not a prospective payment. It is sufficient and clear reasons must be set out. So once you have satisfied all this, then you can proceed with a statutory demand and wind up the company. Now, in most of the situation, if I write a letter to Olivia saying that debtors code, you owe me some money, Olivia is going to come back and say, no, my clients did not owe you any money. It is not clear-cut at all, as indicated in the previous slides. Okay, we have got a counterclaim. We are not accepting that there is debt due and payable. Obviously, you open lots of arguments on this. Now, a number of debts in Hong Kong, if you call it debts, is that it is a prospective claim. It is uncertain because as Olivia is going to come in and say and raise millions of reasons why creditors' code should not sue her clients. And of course, you will venture into the normal civil action procedures. Obviously, this is the procedures which Olivia has talked about. And if you really are very bored and unable to sleep, then this is a rather good chart for you to look at. And you will be looking at how does the litigation procedures commences. You see the pre-action letter, etc. You will see how come there are such funny words like O18 and R1. That's the Hong Kong Civil Procedures rules. It's order. We call it the Order 18 Rule 1. And obviously, the rules when I first started was only one volume. Now there are 4 volumes. Okay, so it has extended throughout in the past 30 years or so. So you can take a look at it when you have time. You can actually see the defense, the counterclaims, etc. Right down to a final judgment. You go to the trial and how many days for the notice of appeal. As Olivia has put it, Hong Kong runs on a very procedural system, very similar to the old English system. So you can actually see that within 7 days, within 8 days, within 10 days, 10 weeks, 20 days to do this. Obviously, we are not, this is the time that we have to stick with. But obviously, the world is not perfect. At times, we will need to seek further extension of time. So there is a slight leeway to extend the time, but usually the Hong Kong courts don't like it. Okay, they would like to stick to the time because for creditors, they would like to get the money or at least get the judgment. For debtors, you may think that let's go and delay the procedures. Yes, this is the process, but most of the time, even for the debtors, they're going to say, let's get it over and done with. Let's find out whether I need to pay. If I need to pay, then I pay. Okay, so the court keeps a rather tight procedures. So the two parties go for a full hearing. Now, very fortunately, my clients got a judgment against the debtors called Olivia's client. Obviously, she will be thinking about whether she should appeal or not. Let's assume that she's not going to appeal. Now, Olivia mentioned the security for cost. So the first thing I'm going to do is that, hey, let's get back the security for cost, because my clients have put in $2 million in court for cost securities. So we're going to get that back. Also, we are going to enforce the judgment. We get a judgment in Hong Kong. We're going to enforce it. We're going to get some money back. So we are moving into the enforcement of judgment stage. These are all debt recoveries, so to speak. Now, if you look at the enforcements, there are two types of enforcements. One we call the treaty arrangements. One is called the common law procedures. For the treaty arrangements, Hong Kong, the jurisdiction, has signed mutual and recognition of court judgments with around 15 jurisdictions. Unfortunately, Japan and Hong Kong, both jurisdictions have not signed any mutual enforcements of judgments. Maybe this is something for the both law society and the bar associations to think about. But anyway, so if there are no mutual recognition of court judgments, then we'll go on to the common law principles. Okay, why go to the common law principles? Because after all, my client has a judgment. It is more like a contract by the court saying that debtors co, you owe creditors co some money. So you go and sue on the judgment. Okay, you sue on the judgment again. So that's obviously for judgments from other jurisdictions. Now, the local enforcement of judgments, there are a number of ways, because as you can see, when you are bored tonight and look at the procedures, you will not see anywhere in the chart that, hey, where is the money of the debtors? Okay, in the whole process, there's no such thing of telling us where is the money of the debtors. So after the whole thing, you get a judgment, there's something called the oral examinations. So my clients can apply to court and ask the debtors to come up and answer a number of questions. So it's a long list. Olivia will not be happy because I'll be sending my letter to Olivia, and she will be advising her clients what to do. So do you want to say something about how, when you receive my letter, asking the company's director to go for oral examination?
To be honest, it's not actually that common to be able to succeed on this. You need to have a really good reason why you should direct the directors to come for oral examination. And this is actually not that common in Hong Kong. Normally, the creditors would just go for winding up of the company. But unfortunately, what they find is that because Hong Kong, most of the companies are limited liability companies. So the liability only restricted to the amount of assets that company actually has. So once you wind up the company, if the company hasn't got much assets, even if Ronald's client, I owe Ronald's client billions of dollars, and my company only has got $10 left. Unfortunately, Ronald's client is left with that $10 to be divided with other creditors.
So that's the reason why in the first couple of slides, it is so important to make sure that the assets are there. Because if you look at the chart, when you reach this the oral examination part or the enforcement part, you are looking at around 2.5 years down the line. So if you are not doing your homework right at the beginning, 2.5 years later, you may be faced with something what Olivia is saying. Well, I've only got $10. So here you go, creditors go $10, and that's it. Okay, so it is very important. But obviously, I'll be thinking about, hey, should I actually go and get an oral examination from the debtors, at least to find out what decisions they have made in disposing the assets. Maybe I get some information, unexpected information as to whereabouts are the assets. Difficult because Olivia will have briefed the directors very clearly and in what to answer and what not to answer. Okay. Now, of course, the more normal way is a garnishee order. As you can see, garnishee order. If the judgment debtor is if the judgment debtor is the creditor of a third party obtaining a garnishee order in the simplest method of enforcement. Okay, this is one of the this is used to freeze or seize the judgment debtor's bank account. This is the most common way to get some money. Okay, so it's nearly in every debt recovery proceedings. This will involve the garnishee orders, prohibition orders, as we call it. We never know. Assuming that the debtor is it's not a company, it's an individual. So on that basis, you do not want him absconded out of Hong Kong. So, and not to pay debts, okay? My clients are actually looking at $10 as well, even if they have no ability to pay the debtors. So we don't want the debtors, assuming it is an individual leaving Hong Kong. So you make an application for a prohibition order prohibiting the debtors, an individual, from leaving Hong Kong. Of course, the creditors will need to seek the assistance, what we call the bailiff section. I remember the two learned speakers from the Hyogo-Ken Bar Association actually talked about this as well. I don't think in Japan they call it the bailiff section. Okay, but in Hong Kong we do. They have another name. I forgot because it was actually on the slides previously. So as the bailiff section, the bailiff, obviously it's valid because the bailiff is located in, if I remember correctly, at the lower ground floor of the High Court. So it is part of the High Court regime, so to speak. So the bailiff will go and seize the goods, take out the chattels, okay, the computers, the desks, etc. Obviously, the bailiff will charge a fee. So a small bailiff fees, and they will go and execute the judgment debts. Charging order, of course, if you know that garnishee is for debts, charging order, no debts, properties, then of course we apply for a charging order to charge the properties. Charge doesn't mean that you can sell the properties. So to make an order for sale of the properties. So you charge it, you charge the properties, no one can touch it, no one can sell it. You make an application to sell the properties. And of course, as Olivia has put it, the most common way is to liquidate the debtors. And let the liquidators do the job, because obviously the liquidators are accountants. They will, the main job is to gather the assets and distribute the assets to all the creditors. And of course, the secured and unsecured creditors position comes in, because once the liquidator gets all the assets and turn it into cash, the secured creditors gets first bite of the money. And if any money left, it will be distributed equally in proportion to the unsecured creditors. So in my case, that's why at the very beginning, I asked creditors code whether they have any securities. If they don't, then there will be the unsecured creditors. And I believe it to be the same in Japan as well. When a company goes into liquidation, the prospects of an unsecured getting some money back, it's not high. Of course, you can see that there's the procedures. Once you go into and apply to one of the companies, then and if there's no objection, or if it is such an obvious case, the court will grant such a petition and official receivers will be appointed. You can actually see that the meeting of the creditors and who to appoint as liquidators. As I said, usually an accounting firm will be doing all the gathering of assets. And in the most simplest form, they gather the assets and sell it, pay it out to creditors. Obviously, there may be some litigations hanging around the debtors. So the liquidators will decide what to do with those litigations. Finally, is the restructuring proposal. Well, debtors co, according to Olivia, she may comes in to say, well, why don't we trade it out? Why don't we help the debtors to save the debtors so that the creditors, you're going to get 10 cents in a dollar. So Olivia then comes in to save the day to say, well, I have got this proposal. Obviously, this has to be agreed by the liquidators and of course the creditors. So these are our usual litigation or debt recovery process, okay, from the creditor's perspective. So I don't know whether Olivia, you have anything further to add.
I just want to add that if the debtor is not a company but a person, and you need to file for bankruptcy against the debtor, the result will be very similar as well. So if that person has no assets, to be honest, you might end up paying more money to lawyers than actually recovering anything back. So the lesson really is you need to do your homework right at the beginning before you do anything, whether it's worth pursuing the litigation and whether this debtor actually has got money to pay back, and whether you need to do all the homework before you jump in and start the whole thing and then find yourself with that basically empty judgment. So that's the last thing you want.
Yeah, I think that's the end of our presentation.
Thank you.
So thank you. Are we venturing into the Q&A time?
Yep. Any questions?
Thank you very much, Mr. Sam and Ms. Kun, for your interesting, fantastic presentations. Now we directly move on to the Q&A sessions for both of the presentation from the Hong Kong side and Hyogo side. And at this moment, we don't see any questions inserted in chat boxes. But
I think Mooney just raised his hand.
Someone raising hands. It's Mr. Kaku from Hong Kong side.
Allow Mooney to speak.
Is Secretary?
Hello.
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 Wonderful. Thank you, Olivia. Thank you, Ronald, and thank you, Tezuka Sensei and Hirate Sensei, everybody for the seminar today. My name is Munenori Kaku. I'm a Japanese but belonging to Hong Kong Law Society, and I have just one quick question to the presentation by the Hyogo-Ken Bar Association. Maybe I should speak in Japanese because this is about the Japanese law, if you don't mind. すいません、本日の講演ありがとうございました。日本法もちょっと昔勉強していたので、どうしてもちょっとお伺いしたいことがあるのですが、多分平手先生が担当してくださった内容かと思いますが、日本国内で債権回収を行うとした場合に、トータルで私たちのように香港で業務を行っていて、例えば考えていくと、我々香港の弁護士が香港の会社と日本の会社の 争いで、日本の会社に、例えば兵庫県にある会社に、訴訟で勝訴をしました。が、資産はおそらく香港にはさほどありません。おそらく日本国内に資産があるということがあると思います。で、その場合に、先生のプレゼンテーションで、触れられていたさまざまな債権回収の方法っていうのは、おそらく日本国民事訴訟法の118条の香港における勝訴判決を日本で一旦118条で承認していただいた上でのお話ということでよろしいんでしょうか。
So, Mr. Hirata, can you make a comments?
はい、おっしゃる通り、118条で承認を得た上でということになります。すみません、私が調べた限り、香港の裁判について、中国返還前に、最高裁が承認を認めたという裁判例は見かけたんですが、今の実例について、手塚先生、何かご存知のところありますかね。
すみません、私も記憶がうろ覚えなんですが、香港か日本の判決、じゃあ香港の判決が日本で執行された例っていうのは一つあるんですけど、かなり古い例で、ちょっと事案もちょっと特殊だった関係で、前回検討したんですけど、一概にその相互主義が満たされるかっていうと、断言はできないのかなという感覚で見てはいます。で、先ほどの、講演の中でありましたけども、双方協定は結んでいないので、相互主義が満たされるかどうかだけが要件というか、判決の相互承認ができるかという要件になるかとは思うんですが、今ちょっとそれは断言できないという状態ではないかなと私は思っています。先例があるというふうにおっしゃる先生もいらっしゃるかもしれませんが、ちょっと古いので、今、なんとも言えないかなと思っています。
そうなんですね。ありがとうございます。なんか昔、民訴を勉強したときは、公助ですね、パブリックインテレストとか、パブリックポリシーに満たして公助に照らして、それがどうなのかって議論もした覚えがあったのですが、あるいは、法制度の違いとかっていうことを見てくるかもしれないですよね。なるほど、承知いたしました。ありがとうございます。以上です。
If anyone has a copy of that judgment on reciprocal enforcements, not the mutual enforcements, it would be good. I have a copy as well because I actually checked. I've actually heard for Hirata-san that I've actually heard there has been enforcement of Hong Kong judgments in Japan before, but as you said, this is a very old judgment. I have not read the case. I am uncertain the procedures in enforcing it, but I have heard very loosely that there had been the odd situation where judgments had been enforced in Japan. But as I said, I've not read the case, so I'm not overly familiar with the procedures then. Yeah.
Thank you very much. For these questions, we've received an input from the attendees in Japan who introduced the judgment of the Supreme Court of Japan rendered in 1998, which says the judgment given in Hong Kong for the cost for the litigation looks regarded as the foreign judgment under the civil enforcement court in Japan. And I haven't seen the Mr. Baku of the Hyogo Association would actually comment, so I'll pass on to him.
すいません、今ちょっとインターネットで調べ直したというか、前調べた記録をもう一回見てみたんですが、返還前の香港との間には相互の保障があるというふうに認定した先例が最高裁かな、これ、最高裁でありました。で、私は古いと申し上げたのは、返還前の香港でということだったので、返還後の中国大陸との関係では逆に先例がないということになってますので、香港の行政特別区が、特定の法領域にあるという形が維持されているという判断であれば、相互主義の、適用があるということになって、いまだに、日本の判決なり香港の判決を日本で執行するということは可能かと思います。逆に中国の大陸の方の法制に従って大陸との間では相互保障がないんだという先例が適用されることになると、相互保障がない、地域ないし国ということになって、執行が今はできないのかなというところで、どちらに転ぶかはちょっとやってみないとわからないということになろうかと思います。
Thank you very much, Mr. Baku, for your comments. And we've received a question from the Hong Kong members. Are there many arbitration awards obtained in Hong Kong and enforced in Japan?
As far as I know, there are not many. It depends on what you mean by many. Okay. I do not have the statistics for it. I've heard that there probably every year there may be the odd one or two arbitration and the Hong Kong awards taken over to Japan to enforce. Actually, I believe Japan is a new. Correct me if I'm wrong. Japan is a New York Convention countries. Yeah. So it's a new convention country, then it will be a lot easier to enforce. But of course, Japan has their own arbitration institutions as well.
Yeah, but I think the arbitration is different from the local court system. So I think if it's an international arbitration award, I do not see there should be any difficulty in enforcing in Japan.
That's right.
So
under the New York Convention.
Yeah.
And then both Japan and Hong Kong is pro-arbitration award bias. In other words, both jurisdictions do enforce each other's awards and it's pro-arbitrations.
Yeah.
Thank you very much. Another question from the Hyogo Bar who's attending remotely. Maybe not a question, but the confirmation. Does the judgment, the Supreme Court judgment rendered, which Mr. Baku mentioned in his comments, is the judgment dated 28th April of 1998, which I think is the judgments introduced by another attendee to the host and panelists, so which can be shared with the attendees later on.
Yes, please. That'll be very useful.
Yeah. I'm afraid the text in Japanese, so we will see if there's any English translation.
I'm sure that Google Translate will be helpful in this situation.
Thank you very much for the questions. There may be some other questions, but in view of the time, perhaps we'd like to move on to the closing remarks. And if there's anyone available or who may remain in the room, virtual room, and can discussion, but perhaps can we move on to the remarks stage now? So now time flies. Now 2 hours have passed since the beginning, and we'd like to conclude this joint webinar by the closing remarks from both the Hyogo-Ken Bar Association and the Law Society of Hong Kong. And first of all, can Mr. Rodenton, Vice President and Chairman of Standing Committee on External Affairs of the Law Society of Hong Kong, can you first kindly give your closing remarks, please?
President Chikui, Vice President Soga, distinguished speakers, members of the Law Society of Hong Kong and Hyogo-Ken Bar Association, thank you for attending today's joint webinar. I'm confident that we have all gained useful knowledge through today's sharing and have a better understanding on the different features and procedures of debt recovery from the perspective of debtor and creditor under the law and practice in Hong Kong and Japan. As our Vice President Amarali said earlier, we are very grateful to have the opportunity to organize the first joint event with the Hyogo-Ken Bar Association since the MOU signed in November 2019. I'm sure it is just the start of our collaboration. We will definitely continue our effort to create more opportunities for professional exchange among our respective members. With a vibrant economy and robust legal system, Hong Kong attracted a pool of legal talents with diverse legal expertise apart from our strong local legal talents. As at the end of October, there were over 11,000 Hong Kong practicing solicitors and 943 local law firms, as well as around 1,500 foreign lawyers from 34 different overseas jurisdictions and 85 foreign law firms in Hong Kong. English and Chinese are both official languages and are commonly used in business. In addition to the cultural familiarity and a shared dialect with the mainland China, Hong Kong enjoys a terrific geographical advantage and is well equipped with world-class financial and legal systems, allowing Hong Kong to serve as a two-way gateway connecting the Greater China and international markets. In particular, being equipped with top-notch local and international legal capabilities, solicitors in Hong Kong are able to provide one-stop legal services to meet different kinds of needs for sophisticated legal services in finance, securities, international trade, cross-border transaction, intellectual property, and much more. What's more, Hong Kong is a neutral dispute resolution venue with world-class arbitration and mediation institutions, such as the HKIAC, ICC, and CITEC, with professionals that are capable of providing efficient and reliable dispute resolution services. Together with the combined advantage of one country, two systems, we are entrusted with the important role in providing a platform for all types of legal rights protection and enforcement. We look forward to fostering a closer relationship and creating opportunities for our respective members, as well as the business communities in the two jurisdictions by organizing more joint events to introduce the unique features of Hong Kong's legal system and services and what Hong Kong professional services can offer to overseas enterprise so as to assist them to explore new markets and business opportunities. Ladies and gentlemen, once again, thank you for joining us today. Hopefully, when the situation allows, we can meet you all again in person in either Hong Kong or Japan very soon. Thank you.
Thank you very much, Mr. Tong. So now, can Mr. Soga, the Vice President of Hyogo-Ken Bar Association, can you please make your closing remarks when you're ready, please?
はい、兵庫県弁護士会の会長の曽我と申します。で、本日はとても素晴らしい意見交換の機会が実現いたしました。とても有意義な情報交換ができたと思います。本日の企画をしてくださった香港理事会の皆様、兵庫県弁護士会の国際交流委員会の皆様に感謝いたします。また本日ご参加いただいた方々にも感謝の言葉をお伝えいたします。ありがとうございます。で今回のテーマですが、兵庫県弁護士会側としましては、半年前からどのようなテーマにしようか、悩んできました。 双方にとって意義のあるテーマとは何だろうかと考えた末のものでありました。それぞれ準備段階、事前の準備段階で相当の労力を割いていただいたものと思います。本日の成功は発表者の準備の賜物でして、発表された方々、ロナルド・サムさん、オリビア・クンさん、そして兵庫県弁護士会の脇山弁護士、平田弁護士には大変感謝しております。で兵庫県弁護士会に属している弁護士数は約1000人となっております。日本全体では約4万3000人の弁護士がおります。外国法事務弁護士は約400人います。日本国内では52の弁護士会がございますが、兵庫県弁護士会の会員数は全国で8番目の規模というふうになっております。兵庫県には神戸港という港がございまして、古くから国際貿易の拠点として栄えてきたという特徴があります。外資系の企業も拠点を置いております。近年では医療技術分野や理化学分野の最先端を行く企業や研究所も兵庫県内に拠点を置くようになっています。他方で自然もたくさんあります。日本国内では有名な有馬温泉や城崎温泉などの温泉や姫路城のような世界遺産もあります。スキー場も海水浴場もありまして、当会、兵庫県弁護士会の会の中には季節に応じたスポーツを楽しむ者もいます。本日は新型コロナウイルスの影響によりオンラインでの交流会となりました。次の交流会ではぜひ直接お会いできたらと思っております。兵庫県に来られた際には、兵庫県の自然や文化もぜひ堪能していただきたいというふうに思っております。美味しいお酒もございます。今後とも末永く兵庫県弁護士会とお付き合いいただけたらと思っております。本日は誠にありがとうございました。失礼します。
Thank you very much, Mr. Soga, for your closing remarks. And now, unfortunately, it's time, so we'd like to conclude this joint webinar. Last but not least, I must confess that this is my first opportunity to be acting as the MC for this sort of English, the webinars delivered in English. So there may be some part which is not well organized. That's the fault of myself, but I'd like to improve my skill for delivering this sort of webinar. So I would be grateful if we can have the joint webinar or the actual seminar in person in the near future, depending on the COVID circumstances. Thank you very much for attending this webinar, and we'd like to conclude now. Thank you very much.